weeks. It's been a pleasure to speak with each and every founder, entrepreneur, and small business that's attended these workshops. As you can tell from the previous two webinars and also this webinar coming up, I'm very passionate about intellectual property. So every business that is here today, thank you again for taking the time out of your day, taking time away from trying to work with your clients to learn a little bit about IP and how it can benefit your company. With that, we're going to get started. As I alluded to before Sam started speaking, I am at the Catholic University of America, and thank you again to them for allowing me to use some space on loan just to host from for the day as I'm in Washington, D.C. for some meetings. This is the last webinar in our three-part series on intellectual property strategies for your business. As you saw in many of the mailers, emails, newsletters, and the Eventbrite, these presentations are made strictly for startups and small businesses, as well as any entrepreneurs that are interested in how they can better use intellectual property for their business. We're going to set some ground rules first for this presentation, and then we're going to keep going through. There's a lot of content to try and cover today. So if I don't get to your question while I'm speaking, obviously I will try and address it at the end during the Q&A, but please feel free throughout the entire presentation to ask as many questions as you want about intellectual property, your startup's intellectual property, and intellectual property generally. Obviously, this is a webinar. This is not me providing you with legal advice for your specific startup. I'm not your attorney. This is just for educational purposes. But again, I am passionate about IP, and I think you should be too, because it can provide a huge benefit to you and your business. Today, we're going to go through copyrights and trade secrets, two other forms of IP that are in addition to patents and trademarks, which we covered in our last two sessions. Also, at the end of this, I've included some bonus slides that are going to go through an IP portfolio for two case study companies. Two companies that I think you'll probably know, and you'll probably know why I use them for the breadth of different IP strategies they use in their own business. A little about me, I'm Daniel Kane. I work strictly with startups and small businesses on everything from corporate formation to government contracts and intellectual property strategies. I have my own firm, the Law Office of Daniel T. Kane, headquartered in New York State, but also representing clients across the country in federal matters, as well as in New York State matters with government contracts or corporate matters. Before going into private practice, I worked at the Small Business Administration down here in Washington, D.C. in a number of roles, but in some, I've been advocating for startups and small businesses for nearly a decade, whether it's in burdensome regulations or just protecting your latest and greatest innovation. Obviously, we've gone through some of the ground rules, but the big one is ask questions throughout the entire presentation. If you have any questions on trade secrets or copyrights, obviously, I'm going to try and get to those first during this presentation. But if you have any questions about patents, trademark, or IP generally, feel free to put them in the chat and we'll get to them when we go into the Q&A session later. A couple slides just to provide some context for people who are joining us for the first time today. I want you to view business as a high stakes game. Your objective is to secure the biggest market share. You are trying to make the most money. You are trying to accomplish the most good. Your competitors are other businesses, other not-for-profits, other entrepreneurs, other innovators who are trying to get to that same goal of biggest market, most money, or most good. The gameplay is a series of defensive maneuvers and offensive maneuvers. So you can think about it as a board game where you have strategic moves you can take, or you can think about it as a big sporting event and one of the professional games that we have in the United States. Football, baseball, each of them can be compartmentalized as defensive and offensive maneuvers. The rounds differ based on what kind of business you are and how you react to your competitors, but generally it's a tit for tat in the economy and in the industry that you're in. These defensive and offensive maneuvers, when it comes to law, can be grouped as such. And a couple examples are here that range from corporate matters to government contracts and a lot of intellectual property. I've highlighted some of the ones that are topical to today, but you'll have seen in previous workshops that I also highlight some for patents and trademarks. Here, Registering a copyright is a great way to protect or defend your authorship, your creative work. Some security measures that you can preemptively take to protect your trade secret. It's another defensive maneuver you can take. Some aggressive or offensive maneuvers you can take are send a cease and desist letter to someone who's trying to infringe your copyright, who's using your image, who's using your sculpture, who's playing your song on the radio without a licensing deal. You also have the way you hire employees. A defensive maneuver is have your employees sign confidentiality agreements. If you have a competitor who has a trade secret that you want, that you don't think is really protected, you can hire their former employees and try and reverse engineer their product. This is a really brief overview of intellectual property, the 4 core forms of intellectual property that every business should know, every business should be thinking about. A patent, a trademark, a copyright, or a trade secret. And those things cover different aspects of your business. A patent is probably going to cover your product. It's going to cover your process, your machine, your manufacturer, or your composition of matter. And it's what you're selling that is useful, novel, and non-obvious to the world. You get a monopoly for that, and you try and monetize that as best you can. A trademark is your brand. What's your company? What's its name? What's its logo? What's its slogan? What are the colors associated with your brand? When I go into a store and I'm looking for your product, what do I look for? What do I listen for? What do I smell for? A copyright is protecting any authorship, any creativity, not necessarily the idea, but the expression of that idea in a tangible medium, whether it's art, movies, code and software, books, other expressions. Trade secrets are information, protecting those ideas that you can't protect in the other ones. It has to be a competitive advantage that you take reasonable precautions to cover. And I saw a question, do you have to have all 4? And the answer is no. Often you do, but you have to pick where you invest your time and your treasure, and try and get the best return on investment. Sometimes a patent is the best bet. But as I say often, many businesses have IP. Not every business needs a patent. Often businesses put the most money into their trademark, into their brands, into the different trademarks they have, the different collections of marks they have, the different logos, the different versions of their logos. Same thing with copyright. Copyright can be monetized by having a portfolio, but you can have any one of these things. You can have all of these things. You can have any combination of them. But it's important for businesses to know that they have intellectual property that gives them a competitive advantage against their competitors. Now, I've said this a few times already, but I want it to really hit home in this last workshop. Not every business needs a patent, but every business has IP. Patents are what every startup founder thinks they need to get an investor, and that's just not true. Yes, having a patent is a huge boom for your business. It could be that you have a great tech. It could be that you have a great process, but don't forget to look for the other 3 forms of intellectual property that I listed earlier, because those could be just as valuable to an investor or to your customers. Sam, do you have a question or a comment?
Yeah, we have a question that came in, Dan.
Sure.
Jacqueline asked, do you have to have all 4? What happens if you have less? Thank you.
You do not have to have all 4. Some businesses are very successful not trying to monetize any of these. But the businesses that are truly successful, the big gargantuan companies that you think of, that we'll talk about at the end, try and monetize each and every one of these, depending on what their business is. If you're a tech company, you likely have some patents. You might have some software, so that's copyrighted. You might have your brand, your trademarks, and then you might have some trade secrets, some things you're developing, some ways of developing those ideas. You do not have to have all 4. They are all their own intellectual property right, meaning that you can get each individual one as you see fit for your business. If you're a nail salon in downtown Cincinnati and you want to make sure that customers are coming to you instead of going to a competitor, you make sure that you have a really good trademark. You have a really good brand that someone's going to know, okay, those are the best best nails in town. That's where I want to go for that. That's where I'm going to send my wife. That's where I'm going to go myself. And they're not going to have a patent. They're likely not going to have any copyrights. And they might have trade secrets, but they're not monetizing them very well. They might have a customer list. They might have a really novel way of putting nail polish on nails. But generally, their big thing is trademark. So they're going to spend their money on their brand. Other companies like an app developer in San Francisco is going to focus predominantly on copyright because they want to protect the software they're writing. They're going to focus maybe a little bit on patents because they might have a process that's really unique that they develop in those apps. Their trademark is probably going to take a back seat. They may protect their trademark. They may develop somewhat of a brand, but they're not going to spend the same money on trademarks that they are patents and copyrights. I hope that answers your question. And so that's actually a great segue to copyrights. We talked about patents and trademarks in the last two sessions, and copyright is one of the other forms that everyone thinks about when they hear IP or intellectual property. Copyright is an expression of an idea in a tangible medium, and you need both pieces of that. And that phrase is highlighted because it's very important. A copyright protects the expression of an idea. It doesn't protect the idea itself, and it has to be in a tangible medium. Because if it's not fixed in a tangible medium, if it's not written on paper, if it's not carved in stone, if it's not on a hard drive or digitized in some way where it can be accessed, transferred, or just merely replicated, then it's likely not fixed in a tangible medium. And there's no copyright because there's no proof. There's no proof that you made it. And you're not contributing to the world's art. You're not contributing to the world's expressions of ideas. Copyright prevents others from reproducing, distributing, performing, displaying, and creating derivatives of your work. So if you write a book and you get a copyright on it, then you can prevent others from reproducing your book and selling it, distributing it and selling it, performing it, so reading it aloud to sell more books, displaying it, so displaying it in their store to try and get more customers to come in, or creating derivatives, creating sequels or prequels or spin-offs. You are really trying to just protect your creation, your expression of an idea, and anything that comes from that expression of an idea. So another example on that book is you may have rights to the movie adaptation of that book. All of these are just to show that your copyright is very valuable on whatever your expression is and can be monetized very quickly if you license for reproduction, distribution, selling, performing, displaying, any of those forms. Often, these are the examples of copyright that people look to. Literature, written works, including software, music, performances like plays or musicals, choreography, images, graphics, sculptures, movies, sound recordings, and architectural works. All of these are expressions of an idea in a fixed, tangible medium. So paper, stone, hard drive, what have you, it's fixed and it's an expression of an idea. A tidbit that I wanted to point out now while we're talking about it is that copyright does not protect everything. Some things are more akin to what we've already talked about. One example is copyright does not protect titles of books. If you want to protect a title of a book, your best bet is to try and trademark the title of the book. So you have a series of books. A good example of this is all of the how-to books that are for dummies. The For Dummies is a logo. It's the title of the book, obviously, but it's protected through trademark. And so if someone tried to do copyrights for dummies, then they likely would be committing trademark infringement unless they'd had a license, or maybe even in one of the other cases that would allow for them to use that trademark. The life of a copyright is very complicated. And this is just trying to get it as simple as possible so you have a quick thing that you can think about when you're looking for copyrights in your business. Anything created after 1978, except for works for hire and stuff that you did under a pseudonym, so fake name, It's the life of the author plus 70 years. And the reason I have last surviving author is if you work on something with someone and it's a joint author scenario, it's the last surviving author's life plus 70 years. If it's a work for hire, meaning that you were hired to design this logo for someone, then you have 95 years from publication of that design or 120 years after creation to have copyright protections for that particular design that you made. Sam, I saw we had a question. Can you pull it up and ask it?
Yes, a question just did come through. Jacqueline asks, can you request copyrights into a contract if you are looking into a job, etc.? Maybe you want to contribute to assist with wording, blueprint, etc. in the future. Can you claim ownership? Thanks. I'm not sure if you got all that at once, Dan.
I think I got it. It's a lot to unpack. So if you are looking at getting employed by someone and you are trying to discern who owns the IP, I think that's a great question to ask, and you're ahead of the game if you are asking those questions at the beginning when you're getting hired. Often what happens is you get hired as an employee in any job by any employer that may, in your job, create some IP while you're doing your job. The company's going to have a clause that says they own it. If you're going into a job where you need to know what their copyrights are, what their patents are, what their trade secrets are, you could ask them to disclose that to you, but it likely will be after you've signed an employment agreement and you've given them some assurances that they're not doing a public disclosure. Other than that, the question's getting to how do you negotiate with copyrights and trademarks and patents when you're looking for employment, when you're looking for a potential customer, or you are trying to work with a potential employer. All of these rights can be assigned very quickly because they are a property right. So a copyright can be assigned to a company, it could be assigned to you, it could be sold to someone else. Same thing with patents, trademarks. All that's to say that when you're negotiating these deals, whether it's an employment contract or a customer service contract, you can specify, if I create anything while I'm doing this job for you, I own it and I will gladly license it to you. Or if I do this job for you, I will assign everything I create to you as part of my job. I hope that answers your question. And if it doesn't, please feel free to restate the question and we'll try and get to it at the end. Now, the copyright registration that everyone knows and everyone talks about is a federal copyright registration. I know we often talk about state registrations and localities getting registrations for the trademarks, for instance. Here, we're strictly talking about federal registrations. And a copyright attaches the moment an author creates something in a sufficiently copyable, accessible, transmittable form. That copyright is not really enforceable until you file a federal registration with the US Copyright Office. And that includes an application, the requisite fees, and a deposit, which is just some copy of what you've created, whether it's a picture, a hard drive, a disk, whatever it is. You provide them with that example and they will review and possibly grant your copyright. Once they've granted a federal registered copyright, you have a lot of benefits, and that's the reason people go after copyright registrations. There's a presumption that you own the work that you just copyrighted. There's an ability to file and enforce your copyright. So you can file copyright infringement actions against people who are trying to copy, distribute, sell, perform, create derivatives of your work that you spent the time and energy developing and expressing in a tangible medium. When you're doing those infringement lawsuits, if you have a registered copyright, you also could get statutory damages, which is a preset amount of money that you get in retribution for them using the copyright without permission from you. Same thing, you can get attorney's fees. You can cover the cost of suing them if it's found to be infringement. The last thing that I want to highlight is that you can actually use the US federal government to enforce your copyright at the border to ensure that there aren't any counterfeit materials coming into the United States when you have a valid federal registered trademark. And you do that through the US Customs and Border Protection Agency. Here's just a slide summarizing how you get a copyright registration. Obviously, you have to express your idea. You have to create the thing. Then you figure out, can I copyright this? Is it one of the things that I can copyright? If it is, you file an application, you provide a copy of what you created to the US Copyright Office, and then you take some measures after it's granted to protect it. That might be a copyright notice, which you often see when you get software saying, this is owned by such and such, year 2021. You have a software license to use it, blah, blah, blah. You may even just put the C like I do on these slides because I've spent the time, energy to express my ideas in a tangible medium, being that I've saved this PowerPoint on a hard drive or on a disk, or I've just frankly digitized it. And so if someone takes these slides and just copies them without my permission, I could try and enforce that, but I haven't done a federal registration for this PowerPoint yet. And once I do, then I can sue people for using this PowerPoint without my permission. So watch out. Ways to monetize copyrights is very straightforward. It's very much like patents and trademarks. It's make it, sell it, license it. You either make the stuff you've copyrighted, so you reproduce your original photograph and you sell it, or you put on the drama or musical that you've authored, you build the building and the architecture that you've created. You could sell it. So once you get a federal registered copyright, you can assign it to another. And that often happens when you're selling a startup or you're selling a company and you have copyrighted materials. Think about any time an artist sells a folio of their works. You can take Taylor Swift, you can think the Beatles, you can think Michael Jackson. Someone's buying the rights to those copyrights so they can enforce them and so they can license them, because licensing is the best and easiest way to monetize copyrights in most cases. And that's the last one. You basically negotiate a contract to either provide an exclusive or non-exclusive, forever or temporary, revocable or irrevocable, full or partial license to someone to distribute, perform, reproduce, or create derivative works of whatever you've created and copyrighted. Now, that was a lot of information about copyright, so I'm going to pause for maybe like 30 seconds to see if there's any questions on copyright right now. Otherwise, we're going to dive into trade secret real quick, and then we're going to keep going into the summaries and then the Q&A at the end. All right. So what is a trade secret? This is the last form of intellectual property that I'm going to be stressing through these workshops. And a trade secret is information that is independently economically valuable by virtue of being secret. It can't be legitimately obtained anywhere else. And you take reasonable efforts to keep it a secret. So has to have value, has to be novel, has to be somewhat new or unknown, and you have to take reasonable efforts to keep it a secret. Registration is not required for trade secret at any point. So keep that in mind. A trade secret is just a trade secret for a trade secret. It's not something that you get from the federal government. You do get recognition of a trade secret from the federal government through the court system, but you do not have to register for it. Reasonable efforts to maintain it secrecy is very important for a trade secret, because if you fail on this piece, you do not have a trade secret and you just totally lose the economic value if someone takes it. These reasonable efforts have to be beyond the normal business practices. So if you have a trade secret, which might be a recipe, it could be an algorithm, It could be just your customer list, your database, a process for how you develop a chemical, how you mix things in the company's warehouse. All of these trade secrets can't have the same security precautions as everything else about your business, because not everything's a trade secret. You have to implement possibly some additional procedures for these trade secrets. That might be a confidentiality clause or agreement for all of your employees saying they will not disclose these trade secrets. Might be just labeling your trade secrets as confidential or confidential business information or confidential trade secret. It might be just physical security to ensure that no one is getting into the facility where you're doing this secret process of mixing the Coca-Cola or creating the nooks and crannies of Thomas's English muffins, the warehouse where they mix the spices for KFC chicken. All of these are reasonable efforts, and that is part of these three things you need for a trade secret. It needs to be economically valuable. I don't think anyone disputes that the Coca-Cola formula is very valuable. It cannot be legitimately obtained anywhere else. It's not something that's widely known. It's not a recipe everyone knows. It's a secret. So there have been reasonable efforts to maintain its secrecy. There's even possibly about some mythology around the trade secret in that there's only 3 people who know pieces of the recipe. Obviously, you're thinking trade secret is probably not something I have. It's very often that you do have trade secret. It's just not as valuable as some of the recipes I've just described. Your customer list, your partner list, your distribution channels, the way you conduct your business. Each of these things could possibly be a trade secret that if someone came in and tried to steal it, you would have lost all economic advantage over your competitors. And you want to protect it, so you'd want it back. And that's where you get into this last prong of misappropriation, meaning someone has tried to steal your trade secret. Someone has tried to steal the invention you're working on or how you develop the new inventions in your warehouse. If that happens, you go to federal court and you show these 3 things: economic value, the legitimately obtain the information, the reasonable efforts, to show that they misappropriated, meaning they stole your trade secret. And you can try and get it back. You can try and prevent them from disclosing it to anyone else. And you might even just prevent them from using the trade secret, even though they know it. These are the steps generally for trade secrets. Obviously, you start with identify your competitive advantage. Is that a recipe? Is it an algorithm? Is it your customer list? Is it a method of doing something? Is it secret? Is it something that's already out there and everyone knows? Or is it something that only I know and I'm taking the reasonable efforts to protect it? If that's the case and you've put in those reasonable efforts, then you just want to make sure that no one accidentally or intentionally discloses it to someone. So accidentally often happens with employees, often happens when a former employee goes to a competitor. Could be intentional, could be someone hacked into your systems to steal the recipe. Each of those can be enforced in federal court under the Defend Trade Secret Act. These are 2 considerations for trade secrets. And I highlight these just because you should be cognizant of these if you're going to go the route of trade secret. Reverse engineering is someone's ability to figure out what your thing is, to figure out how something is made, to open up the device and see how it works. If they can do that quickly, you're likely not going to have a very enforceable trade secret. If, however, it takes years and years and years of finding that true balance of different components, then you have a fairly valuable trade secret. If you get into a trade secret litigation or trade secret dispute, this reverse engineering piece really comes into play because it shows whether or not they were taking those reasonable efforts to reverse engineer it. That also plays with whether to choose a patent or a trade secret. Often, if you create something new, novel, and non-obvious, you can go one of 2 ways. You either go for a patent, where you make a public disclosure in exchange for a 20-year monopoly, or you go a trade secret route, where you keep it a secret forever or as long as you want to monetize it. And in exchange, if someone develops it without your intervention, without your information, they can just start using it. If someone found the Coca-Cola recipe, and by found, I mean they just made it themselves by happenstance, Coca-Cola can't sue them for trade secret misappropriation, and they can't stop them from making it. The only way they could stop them from making it is if they tried to trademark it the same way, or they tried another kind of IP. Trade secret would really be lost there in that hypothetical. Now, before we get into the summary piece, I just want to highlight again, not every business needs a patent. Every business has IP. And this truly should hit home for everyone because everything we've gone over in this workshop, every piece of this series has highlighted one or more components of intellectual property. And it's very rare that a small business does not have at least one of these things. It might be that it's not valuable to monetize it at this point, but every single business generally has one of those 4 forms of intellectual property. I have 2 case studies here to highlight the portfolio of intellectual property that you want to develop with any company, whether it's a fledgling startup, a small business on the corner of Main Street, or a multinational corporation. You want to try and get as much intellectual property as you can across these different spheres of patent, trademark, copyright, and trade secret to maximize your market share, the amount of money you make, or the good that you accomplish. And you want to do that before your competitors do. And I highlight those things just to allude back to what we talked about earlier. This is all a game. This is just one big high stakes game, trying to make the most money, get the most market share, or accomplish the most good before your competitors do. And you can do that by using your intellectual property rights to your advantage. Apple Computers specifically, has a whole slew of intellectual property they monetize, whether it's the products themselves, the licensing deals they do, the partnerships they develop, or generally just how they monetize what they've done at Apple and the ideas they have. Starting on the left, you have just a truly small list of the trademarks that Apple uses on its products, its software, its websites, its materials that it doesn't want anyone else using. And if you see or hear AirPods, you immediately think Apple because they've trademarked it and they ensure that only Apple products have AirPods on it. If you move into the center of the screen, hold on, Sam, for 1 second, because I'm going to finish this case study and then I'll answer the question. So Apple then has a ton of patents. Obviously, with Apple being a technology company, some of these patents are on the tech itself, on the circuitry, on the process of doing things. The most bottom diagram is actually part of a very recent patent where an Apple Watch can take an EKG and other biometric data by using the dial and other sensors in the watch. Apple was the first to do this in this way, so they got a patent on it. And that specifically is a utility patent, which we talked about in our first workshop. If you go one step above that diagram to these 2 cell phones, you'll see a design patent, which is patents that covers the layout that you see, the user interface. This was actually a very contentious patent that Samsung was found to infringe and cause a $1 billion settlement between the 2 companies, all because Apple was protecting the way their app layout, their logos, their interface looks, the ornamental aspects of their iPhone. If you go down into the bottom right, you'll see a few more patents that they have, some more recent than others. That wrist in the bottom is for another capability for an Apple Watch. The one above that is for alternative reality or augmented reality. And the farthest one on the right is just a patent on the slide bar to shut off your phone or to unlock it, which I know might not be present on the current iPhone, but we've all used it and we've all seen it. And just think, that was patented by Apple way back when. The last 2 forms of intellectual property are not as easily displayed for Apple. Apple is very strict about their trade secrets. And they will often sue former employees because they stole their trade secrets and went to a competitor, or they disclosed it to a journalist or to someone in the public, which could truly get rid of that trade secret for Apple because it's no longer a secret. And once it's out of the bag, it often stays out of the bag unless you can get the federal courts to pull it back in. Also, this copyright notice is for some copyrighted Apple software back from 2012. You'll often see this on any of the Apple products that you download. You'll see that they have a copyright on the actual coding. And if you get the software from them, you are merely just getting a software license. So you're getting a license to use it rather than the actual product itself. All right, Sam, what was your question before I move on to the next example?
We had a question come in. What about a resume? Sometimes people copy other people's resume thinking outside the box. Thanks.
It's a great question. And I also like that you're thinking out of the box. So if your company, for example, let's create a startup. Your startup is resumebuilder.com. I think Resume Builder actually exists, but I'm not entirely sure off the top of my head. Your whole business is constructing unique resumes for people. So you would have the process of constructing a resume for someone using whatever information you get. You would have the actual look of the resume, and then you'd have your branding to ensure that they knew it came from you, came from resumebuilder.com. That first piece of the process of how you develop the resume for a particular client might be patentable. It might be a trade secret that you have that you don't ever disclose and you keep it a secret. Either way, it's a process. And as we saw in workshop 1, a process is often patent eligible, so long as it's new and non-obvious. So it's something that other people aren't doing already. It's not something one skilled in the art would already do. That second piece of how the resume looks, that might actually be eligible for copyright. It's up to you whether or not it's worth it, whether it's worth it to go through the registration, worth it to try and enforce it. Is it truly that unique an idea? But you're expressing an idea onto a tangible medium. You're expressing the idea of what do I write? How do I lay it out? What information do I want to convey in a tangible medium, the paper, or the hard drive that that electronic version is downloaded on. That last one is your brand. Obviously, that's trademarks. Obviously, if our business is resumes, then we're going to have some great trademarks saying Resume Builder or resumebuilder.com that we put on the document as a watermark before they buy it, or as part of a sleeve that they get it in to show that it came from us, that it's a certain quality, came from a certain source, has certain characteristics. So they know if they like that resume, they come back. But to answer your question really succinctly, yes, you could try and copyright your writings, which might just be a physical resume itself. The question is, how do you actually put that into practice and how do you monetize it? And the last case study I have is Nike. Now, oh, Sam, do you have another question before I move on? Sam, you're on mute.
Yeah, we have another question from Tom. A trade secret question. Let's say a vendor published a white paper that described a unique way to solve a problem for their customers. They put that paper behind a registration form, but the registration is open to anyone. They want to use it as a marketing piece, but even competitors could register and download it and benefit from the information. What would that considered? Would that be considered a reasonable effort to protect the trade secret? Would a competitor be liable in any way if they downloaded it and benefited?
So if we're saying, so if we go through the process, what's the trade secret that we're looking at? What's the trade secret we're identifying first? And it seems it's that that unique process or that unique performance that they're doing for a client that they've included in that white paper. And they disclose the whole process. Let's just assume that. If they're putting it in a publication that then they distribute to anyone and everyone, so long as they give them an email address or some basic registration information, then it's likely not meeting that threshold of secret because it's publicly available. It's anyone can get it. And so if a competitor is trying to use that same method, it's likely no longer a trade secret. That competitor, its next best chance is to try and patent that process within 1 year of that public disclosure. So likely 1 year from the start of that white paper's distribution. I hope that answers your question. The last case study I have is Nike. As a former college runner, Nike's always top of my mind because we were a Nike school. And Nike's IP portfolio I find very interesting because it's not what you think it would be. Obviously, it's a fashion company or an athletics company, depending on who you talk to. So it has trademarks at the foundation of its IP portfolio. The Nike swoosh, Nike itself, the Just Do It slogan. Blue Ribbon Sports is an homage to Phil Knight's first version of Nike called Blue Ribbon. And the other brands that fit into Nike, like Air Jordan or just Jordans. Those are all trademarks, which you often see when you're buying anything that's fashion or an article of clothing or equipment, because you want the customer to know, oh, those are Nike shoes. Those are really good running shoes. Or, oh, that's a Wilson mitt. That's a really good baseball mitt. You want the customer and anyone who is around the customer to know that's a good quality. It's from a certain source. It has certain characteristics. It alludes to a certain status. All of that's done through trademark. But if you move into the center of your screen, you'll see that Nike also has trademarks on the soles of its shoes because they have a very unique look, and not every one of them is to the threshold of being patentable. It's not so new, novel, and non-obvious that you can get a patent on that technology. That's not to say that Nike doesn't have patents, though, because Nike does have several patents on its shoes, on the way its shoes are constructed, on the services for their shoes, which is the patent drawing to the right. That's actually for a blockchain foundational shoe augmented reality product. It's basically called CryptoKick, where you can have an NFT for a particular shoe. And that, in layman's terms, is just a way of creating a scarcity for a digital asset or a tangible asset based on a digital token, like a shoe. That's a very recent patent that they filed and just shows that it's not just shoes that they get patents on. They get patents on various things within their business. They also have a ton of trade secrets as they're developing these products, as they're working on different lines, as they try and develop the new greatest running shoe. And they protect those trade secrets pretty vehemently against disclosure and misappropriation, often suing former employees, designers, or anyone who's misappropriating those secrets. The last one is copyright. They do have copyrights, and copyrights can often cross over with trademark. And I wanted to highlight one that's come up in the NBA because there is an athlete that had designed their own logo way back when, had filed for copyright on it, and Nike was one of their sponsors and was using a derivative, arguably, of that logo. They got into a contractual dispute. They immediately tried suing one another for copyright infringement on both cases because they had both designed logos. And that's in the bottom of your screen. They have a copyright on that design, which they then could turn and file for a trademark on as they use it to sell products. But the difference there that I want to hit home so you don't get confused about trademarks and copyrights is the copyright is protecting the expression of the idea, but it's not necessarily being used in commerce to denote quality, origin, or characteristics. To do that latter piece, you want to get a trademark. So you would take that design that you designed yourself that has a copyright on it and walk over to the USPTO and get a trademark on it so you can use it in commerce and prevent other companies from selling things using that mark. I hope that makes sense, but both of these case studies are to show that to be a truly successful, huge company, it's very likely that you are going to have a portfolio of intellectual property that includes all four forms, whether they are siloed and discrete in their own areas, or if they're overlapping the same way that you see shoes not only being patented by Nike for certain designs, like their lunar molds, but also trademarked. So you have the particular imprint of the shoe denoting it's a Nike shoe. With that, I'm going to conclude the IP workshop series and answer any questions you have about patents, trademarks, trade secrets, or copyrights, and how to monetize them or any of the strategy behind them.
Thank you, Dan. Much appreciated. A lot of great insight there. If anyone has any questions, we're going to be taking a few minutes for Q&A. You can put those in the chat at the bottom right of the WebEx portal. But I do have a question here, Dan, that came in. How do I copyright a company or a company project or marketing materials? Can I do so? And if so, do I have to do each separately?
Keep in mind that you are talking about two forms of IP there. For a company, you are likely trying to protect the name of the company. So that's a trademark. You want to file for the name of the company, or you want to file for the logo. Where copyright may come in that respect is if you designed the logo and you want to get a copyright protection on the logo just because it's a unique design. But that's often not the case. It's truly, the focus is truly on trademark, and whether or not you want to get trademarks for the logo itself, the name of the company, the brands of different products you have, what have you. The copyright comes in if you want to copyright those materials, the written works that you've developed, the presentations you've given, maybe some of the graphs that you include in your presentations to clients. If those are your own unique creations in a tangible medium, so stored on a hard drive, CD-ROM, disk, whatever, then you can prevent others from stealing it and copying it, or at the very least try and enforce against them. So what you're talking about are actually two IP rights, trademark and copyright. But yes, generally you could try and monetize and protect your company's assets like marketing materials, presentations, etc. through copyright, and do that by filing with the U.S. Copyright Office.
Thanks, Dan. And if anyone has any other questions, feel free to throw them in the chat. We did get a lot of thank yous, Dan, in the chat. Brad said, thanks, Dan. Nice clarification between when to use copyright versus when to use trademark. A lot of thanks from everyone in the chat. Jacqueline also said thank you. So if no one has any other questions, we'll give you guys a couple more minutes, but I'm going to go over some closing housekeeping items. First of all, Dan, thank you for being here for the last 3 weeks. We really appreciate your insight, your expertise to our entrepreneurs and our community at Ignite U. This is recorded and will be reshared tomorrow, if not Friday, on our social media and YouTube channels. So if you guys wanted to rewatch it or share it to a colleague or a friend, you will be able to do so maybe by end of day tomorrow. And then we are also still accepting applications for our 2021 Summer Accelerator Program. That's an opportunity for you to spend 8 weeks with our team at Ignite U, our subject matter experts such as Dan, our mentors, and have access to our resources to continue growing your company, whether you're trying to raise money, whether you're trying to find new clients, learn how to better sell your product or services. You get to spend 8+ weeks with us for free. We don't take any equity. And applications are still going until June 4th. I did put a link in the chat if you guys want to access that. Whether you guys want to apply directly or whether you want to refer a company, we did extend the deadline a few more days because of the holiday weekend. Other than that, thank you very much, Dan. We really appreciate your time and your expertise over the last 3 weeks. And if anyone has any other questions, we'll stay here for a minute or so. In the meantime, while Dan and I maybe take our quick screenshotted selfie here for a big old thank you on the social media pages. So Let's see here. If you want to do one with your contact information.
All I would add, Sam, is that I cannot recommend the accelerator enough. Obviously, I'm one of the subject matter coaches, so I'm a little biased, but I think Ignite You does a great job cultivating startups and small businesses throughout New York State, but also across the country, and helping them develop their product, develop their company, develop their culture. And I truly hope that each and every one of you who hasn't already gone through the accelerator really think about it before you leave today's webinar and before the deadline passes on June 4th.
Thank you, Dan. Yeah. And it's a great opportunity because we're non-dilutive. We don't take any equity. So there's no harm in applying it and being a part of the program as well. We're going to do a 1, 2, 3 cheese here, Dan. How does that work? 1, 2, 3 cheese. Perfect. You guys got to see that candid in real time. All right. Thank you, everyone, for being here today. If there's no other questions, we're going to let everybody go. Thank you again, Dan. If you guys have any questions for Ignite You, you guys know how to reach out to us on social media. If you guys have any questions for Dan, hopefully you're connected with him on LinkedIn or got his contact information. You guys have a great rest of your week. Thank you again, and stay tuned for future webinars.
Thanks, everyone.